You have a hearing in federal court in Arizona and you don't know what to expect. Here's what I need you to understand. Federal court is a completely different system than state court. Different rules, different judges, different sentencing guidelines, and the prosecution has resources that the state prosecutors can only dream of. Your first hearing, the initial appearance, can determine whether you walk out or sit in federal custody for months while your case moves through the system. What do you say at that hearing? Whether you have an attorney present, those things matter enormously. I'm Richard Suzuki. I was both a former federal and state prosecutor in this district. I sat at the government's table. I know exactly what happens at every stage of the federal process and whether one wrong move costs you everything. That is what nobody tells you before your first hearing. Federal court versus state court. They are not the same game. The first thing you need to understand is that federal court and Arizona state court operate under completely different rules with different players, different procedures, different sentencing systems, and dramatically different resources on the prosecution side. In state court, the county attorney's office prosecutes cases. There are local prosecutors handling thousands of cases, everything from DUIs to murders. Resources are real, but stretched. In federal court, the U.S. Attorney's Office for the District of Arizona prosecutes cases. These are federal career prosecutors who work cases involving narcotics trafficking, alien smuggling, human trafficking, organized crime, firearms offenses, fraud, public corruption, immigration crimes, and more. They work with federal investigative agencies, the FBI, DEA, ICE, HSI, ATF, IRS, criminal investigation. The resources are federal, the investigations are thorough. The cases, by the time they reach an indictment, are typically well built. The conviction rate in federal court is approximately 99.6%, including guilty pleas. Among cases that go to trial, the government conviction rate is still staggeringly high. This is not because federal prosecutors are always right, it's because the system is structured, resourced, and populated with experienced professionals who know exactly what they're doing. Understanding this is not about losing hope, it's about approaching the situation with clear eyes. The initial appearance. The federal process starts with your initial appearance before a federal magistrate judge. This is typically your first court date, and it happens quickly, often within 24 to 48 hours of arrest on a federal indictment or complaint. At the initial appearance, the magistrate will inform you of the charges, advise you of your rights, and address the questions of whether you'll be released or detained pending trial. This is important. The federal system does not use traditional bail the way state courts do. Instead, the question is where there are conditions of release that will reasonably assure your appearance at future proceedings and the safety of the community. If no condition can satisfy those requirements, you can be detained indefinitely pending trial. Federal pretrial detention is real, common in serious cases, and something your defense attorney needs to be fighting aggressively from day one. The detention hearing, one of the most critical moments at or short after your initial appearance. The government can request a detention hearing. This usually happens at the initial appearance itself, though either side can request a short continuance up to 3 days for the government or 5 days for defense before the magistrate judge. At this hearing, a prosecutor argues why you should be held without bail. Your defense attorney argues why you should be released. The hearing matters enormously, and most people don't understand why until they sat through one. If you're detained pre-trial, you are fighting your case from jail. You can't assist your attorney in gathering evidence. You can't maintain your job, your housing, your family stability. You're more psychologically depleted going into plea negotiations and trial. Studies consistently show that pre-trial detention correlates with worse outcomes. The government can argue for detention based on two things: flight risk, meaning the judges can't be confident you'll show up for trial, or dangerousness, meaning your release poses a danger to others or the community. For certain charged offenses, the law creates a rebuttable presumption of detention, meaning the default is to hold you unless you can demonstrate otherwise. Your defense attorney needs to be prepared to counter both arguments with specific evidence: employment, community ties, family connections, a clean record, evidence of stability, and proposed conditions of supervision. This is not the time for a boilerplate argument. Every detail matters. Discovery in federal cases. Federal discovery is governed by the federal rules of criminal procedure and by the constitutional obligation established in Brady v. Maryland. The prosecution is required to disclose evidence that is material to guilt or punishment, including evidence that could help you. In practice, federal discovery in complex cases is enormous. Drug conspiracy cases can involve thousands of pages of investigative reports, recorded phone calls, and intercepted communications, financial records, surveillance logs, laboratory analysis, cooperating witness statements, and more. Reviewing all of it thoroughly is not optional. It's where defenses are found. Beyond the formal disclosure, defense attorneys in federal cases also file motions to compel additional discovery and specifically request items that might not otherwise be turned over. The CI's complete cooperation history, the deal they received, any prior criminal conduct, a payment they received from the government. This information can be extraordinarily important to the defense. The United States Federal Sentencing Guidelines. Here's what shocks people the most when they enter a federal system for the first time. Federal sentencing is governed by a complex point system called the United States Sentencing Guidelines. Federal judges don't just decide based on the charge what the punishment is appropriate, they calculate it. The guidelines assign a base offense level to a charged crime. The number gets adjusted upward or downward based on specific facts. The amount of drugs involved, the presence of a weapon, the defendant's role in the offense, whether anyone was harmed, whether the defendant accepted responsibility, and several other facts. The defendant's criminal history also produces a separate score. Those two numbers, offense level and criminal history category, produce a sentencing range in months. Federal judges are not required to sentence within the guidelines after the 2005 Supreme Court decision, but guidelines are still a starting point for every federal judge, and judges must calculate and consider them. Most federal judges still fall within or near the guideline range. What this means strategically. The guidelines can be attacked. Every factual finding that adjusts the guideline upward can be contested. A skilled federal defense attorney fights the guidelines calculations itself because a few points on the offense level can mean years of difference in a sentence. Cooperation agreements. One of the most significant options available in federal cases is a cooperation agreement. If a defendant has information about other criminal activity, co-conspirators, suppliers, other criminal organizations, the government may be willing to negotiate a plea that includes a substantial assistance provision. If the defendant's cooperation leads to prosecution or convictions, the prosecutor can file a motion asking the judge to sentence below the mandatory minimum or below the guideline range. Cooperation is not the right choice for everyone. It carries real risk. It requires truthful disclosure of everything you know, which can have implications for others you know, and it requires testimony that puts you at personal risk in some cases. But when the facts support it and it's properly negotiated, cooperation agreements have produced dramatically reduced sentences in serious federal cases. The decision about whether to cooperate, and if so, on what terms, is one of the most consequential decisions in a federal case. It should never be made without experienced federal defense counsel who knows how those arguments work in the District of Arizona specifically. Completing the federal trilogy. What you need to know, we've covered how federal drug investigations are built. We've covered how the grand jury process works. And now we've walked through the federal court process from initial appearance through sentencing. Together, these three videos give you a complete picture of the federal system in Arizona from someone who spent years on the prosecution side. The through line of everything I've told you in these videos is this. The federal system is powerful, well-resourced, and statistically stacked against defendants. The 99.6% conviction rate is real. The mandatory minimums are real. The sentencing guidelines are real. But so are constitutional protections. So are evidentiary challenges. So are effective motions, skilled negotiations, and the strategic use of every tool the defense has available. The government's case is built by human beings who make mistakes, rely on witnesses with their own agendas, and sometimes cut corners. Finding those weaknesses and exploiting them is the work that we have to do. And having an attorney who built cases on the government's side, who knows exactly what the ASUA sitting across the table from you is thinking, what they're confident about, and what they're worried about, that's a different kind of defense than you get from someone who's only ever seen the system from the prosecution side. We've covered a lot of ground on this channel, from the moment of the arrest to federal courtroom. But there's one question that comes up more than almost any other, and it's one where bad advice can do serious damage. Should you talk to the police? Not during a traffic stop, specifically when investigators want to question you about an alleged crime. The answer is almost never what people expect. That's the next video, and it's one of the most important things I'll put on this channel. Don't miss it.